Translations and added matter, what the Court of Appeal just clarified. In a decision of 5 November 2025, the UPC Court of Appeal delivered one of the clearest statements so far on how translations of non-EPO language PCT applications are treated in an added matter analysis. The case was Seoul Viosys versus Expert E-commerce, and while the patent itself was revoked, the real significance lies in the translation principle the court set out. Here is the core message. When an international, so PCT, application is filed in a non-EPO language, in this case Korean, the translation filed on entry into the European phase is not a mere formality, it is the operative text that defines the content of the early application for the purposes of Article 1232 EPC and Article 1381C EPC. And crucially, there is a prima facie presumption that the applicant's translation is accurate. It is the applicant who provided this version, and the EPO relied on it for search, examination, and grant. So, if the proprietor later claims that the translation is wrong, the burden of proof lies entirely with the proprietor. You cannot simply point to the original Korean text and say the translation was incorrect. The court made clear that this is not enough. So, to overcome the presumption, a proprietor must put forward substantive linguistic evidence, typically, the court indicated, a party expert qualified in the source language who can demonstrate why the previous translation was inaccurate and how the correct meaning aligns with the claimed subject matter. Without such evidence, the court and third parties are entitled to rely on the filed translation as the definitive version of the early application. So the logic is simple. It is the applicant's own interest to ensure that the European phase translation reflects the true content. Once submitted, legal certainty requires that others can trust it. Takeaway: for PCT applications in non-EPO languages, the translation filed on EP entry is presumed correct. If a proprietor later wishes to argue otherwise, the evidentiary burden is high and expert linguistic testimony may be essential. Thanks for watching. See you next time.